Hereby, I open this academic ceremony in which Jana Nysten will defend the academic thesis, Can You Sue Away Climate Change? An examination of the potential of climate change litigation to fill gaps in the global governance for greenhouse gas emissions reductions. May I invite you to present a summary of your study and the conclusions of your thesis.
Thank you. Dear Pro-Rector, dear members of the Corona, dear audience, I now have the pleasure to introduce you to my research and present you with my results. First, why did I write a book about climate change litigation? Well, having studied law in the Netherlands and working in energy environmental law, and here specifically in the field of climate change, I followed the Dutch courts in the agenda litigation. In fact, I remember I was asked by my colleagues to explain what the Dutch courts were doing there. I also got questions from quite a bit of friends. And when I was reading those judgments and answering those questions, I realized that climate change litigation is by no means a Dutch phenomenon. There were a number of cases from other jurisdictions that caught my interest. Plus, everyone was suddenly writing about it, or at least that is what I felt like. And that abundance of literature and the rising number of cases did not satisfy, but rather increased my interest. Most of the authors out there seemed to write with a certain agenda. For example, some of them, you might call them proponents, they argued that climate change litigation could be a solution to the, oh no, it's right. I'm sorry, I get confused by the two screens here. Some of them, you might call them proponents, argued that climate change litigation, now it's jumping, and this is very confusing, I'm really sorry. So, I hope this stops, so. So coming back to that, some of them, you may call them proponents, argue that climate change litigation, based, for example, on human rights, could be a great solution for the gridlock that we see in the negotiations on international climate change treaties. Others, more of the opposing team, referred to the idea of separation of powers, for example, and warned the courts against becoming too progressive and interfering with the competences of the other branches. And there are authors, maybe also more in the opponent camp, who say climate change kind of doesn't fit with the legal system as we know it. They refer to, for example, the issue of causation and say with climate change, it's not that easy to prove causation and it doesn't fit with, let's say, the German jurisdiction on that. Others say courts and judicial bodies, they are not experts on climate change. We don't want them, or maybe they even can't, read the science and make laws and regulations on it. So with all that background, I wanted to find out what climate change litigation can do. This led me to my research question on the potentials of climate change litigation to fill gaps in the global governance for greenhouse gas emission reductions. Now, with my work, I wanted to have something that is more general and neutral in the examination. I didn't want to write another book that pursued an agenda and that was arguing in favor or against climate change litigation. Rather, I wanted to have something that works on a higher level of abstraction and that looks at a variety of different cases and tries to defer what in general we can expect from that. So, what did I do? First, I thought if I want to look at the gap-filling potential of climate change litigation, I first have to see whether there are actually gaps that need to be filled. So part one of the study is a brief assessment of the gaps in the global governance for greenhouse gas emission reductions. I take the example of rules on greenhouse gas emission reduction targets for states and instruments to achieve them, and I assess whether those rules are sufficiently certain that you could say the system works, or whether there are uncertainties, which I call gaps in the study, and which climate change litigation could possibly fill. The second part is then dedicated to the question of whether climate change litigation has been used, and thus can be used, to fill those gaps. And in the third part, I assess the factors that may limit climate change litigation in this undertaking. Here I discuss state sovereignty, separation of powers, and science as the three most dominant factors that I could see from reading the judgments and reading the literature discussing the judgments. I chose those categories because they're sufficiently broad that you can put other discussions under them. So the part is relatively extensive, even though those are just three factors that I announce here. Now, this already leads me to the fourth part, which are my findings. And in that, I would say there is no one-size-fits-all answer as regards what climate change litigation can do. Rather, it depends on the type of climate change litigation that we're looking at. I distinguish between climate change litigation against states, climate change litigation against the executive and legislative branches of a state in national courts, and climate change litigation against private entities, which also takes place in national courts, while the climate change litigation against states is in international courts and tribunals. And this distinction is, it turns out, justified because on the international level, when it comes to climate change litigation against states, what we will find is that those cases are often limited by the concept of state sovereignty. As international law is based on essentially the state's consent to some point, so the rules of international law reflect what the states have agreed to do, may that be in a treaty or in customary law. The courts and tribunals hearing those cases and ruling in those cases will often find themselves in a position where they have to remember their competences and have to try to not offend states when making, I would say, progressive judgments. So you will often see a balance in how far they dare to go and where they draw a bit back. This is very often characterized by what is called a margin of appreciation or discretion that those courts and tribunals grant to the states. So they do not prescribe the entire rule, but they say there is room for the states to differentiate. Climate change litigation on national level, however, which may be against the executive, the legislative, or private entities, is often limited by the separation of powers. Thereby, it is important to note that separation of powers is not a universal concept, and it's not applied in the same way in different states. So it will depend on how far a court can go on the jurisdiction to a great deal, and on the understanding of the society in that jurisdiction of the role of courts. Another important factor is the national law, because there are different causes of action available in different jurisdictions. And in my work, I do not look at the different causes of action. I mention examples, but I'm not doing a comparative law study on the, I don't know, like the provisions of criminal law in the European member states compared to the United States and whether you can use them in the case of climate change. I'm not doing that. I'm just taking out examples and say, this is what they use there, this is what they use there, but they essentially run into the same problem at some point. And that problem is that similar to their colleagues on international level, the national courts will also have to look to their own competences, and they will have to look to how far they can go without interfering with the competences of the executive and the legislative branch. And that is similar in all climate change litigations on national level. So, last point, overall conclusions. Does that mean that I'm totally hopeless on the issue of climate change litigation, or do I see it as a solution? Well, personally, I would say I don't expect a revolution from climate change litigation, and I think you have to be very cautious with your expectations. My work shows that climate change litigation can contribute to the development of the global governance for greenhouse gas emission reductions, but more in a cooperative process, more in an interaction between the different actors, and by that I mean states as such on international level, but also on national level, the political and legislative institutions and society. So I think it is going to be more of a dialogue, and it's going to be a slow development. And then I think within that framework, climate change litigation can make a meaningful contribution. But yeah, that is actually where I wanted to rest my case. And now I'm happy to give back the word and answer questions.
Thank you for your presentation. We now start with the opposition. The opposition will be opened by Professor Eliantonio. Professor Eliantonio is a professor of European and Comparative Administrative Law and Procedure at Maastricht University and the chair of the assessment committee.
Thank you very much, Mr. Prorector. Dear candidate, congratulations, first of all, for having written an engaging, well-researched thesis on a most interesting topic, certainly one that will keep us busy for a long time, as you have suggested yourself in your presentation. I particularly appreciated your capacity to stretch your lines of inquiry from public international law to constitutional law and tort law and more. My question for you today concerns a topic which is very central, as you say yourself in your book and today in your presentation, in climate change litigation, namely the way in which courts engage with science, and in particular scientific arguments brought forward by the parties. And as you correctly point out, polarization or polarized discourses about whether courts are correctly able to or are able to correctly understand the scientific points and the science behind certain claims is not helpful. We should not polarize the discourse, but you also point out that the question of science in courts depends on many different factors, including the complexity of the specific scientific argument, but also the evidentiary standards that are applicable, the availability of independent experts, and so on. However, it seems to me that in your thesis you stop there at bringing forward those points, but you don't seem to want to plead for more or less engagement with scientific questions by courts. So my question for you today is, first of all, what is your point of view on which direction ought to be taken by courts in this situation? So should courts engage more with science and risk getting it wrong, between inverted commas? Should they be more reticent in respect of such claims, especially when courts are not composed of also experts, but also but only generalist lawyers? So that would be a first part of the question. The second part of the question is what you would propose in this light, what you would propose as possible improvements in the way in which courts function to reach your preferred option? Should procedural ecosystems change in one way or the other to make them more suitable, more appropriate to listen or to hear scientific claims by courts? Thank you.
Yeah, thank you for your question, my highly learned opponent. That is a super interesting question, and I was myself thinking about it, in fact, just this weekend when I prepared for this, because I was rereading the judgment Klimaatzaak versus Belgium, and I was thinking, actually, I think the court there does quite a good job. Because what they did is not only they looked to the IPCC reports, but they also invited an expert on that. And if I read them correctly, they confronted the expert back with questions that they had about the science presented to them by the parties, and especially the 55%. They at some point, the discussion was whether Belgium should reduce their greenhouse gas emissions by 55%. And the court gave that back and had a pretty good, I think, discussion around whether the scientific arguments would support that 55% or even a higher target. And they concluded in the end, with the help of the expert and the help of the data presented to them, that they didn't find enough evidence for a higher target, but they could fall back to the 55 because Belgium at some point had themselves set that 55. So they kind of turned the, I want to say, the burden of proof around, because they said, okay, we cannot set a greenhouse gas emission reduction target for you. But if you had 55% at some point, then please prove to us that changing that was a mistake. And I think that's a very interesting way, because it brings the court away from the territory of the executive or the legislative or, let's say, the scientists in the room, back to the one of the task of a court to say, okay, you defend your case, and I see whether I find this convincing or not. Because I agree with you. I think it is problematic, and I know that Marianne Peters has written about this as well, and I really like this. She raised the question of how much courts can rely on the IPCC reports and whether they can read them correctly. And if you look to a lot of climate change litigation judgments, including the European Court on Human Rights, they often refer to the summary. And I'm like, I have no problem with them referring to the summary, that's okay. But if they understand the summary incorrectly, or if they overlook things in the summary, I wonder why they don't have an expert. And if I see a Belgian court going there and saying like, okay, we hear an expert on the report that helps us understand it, I think that's actually a good way. I don't want to waste resources on having expert on each and everything, and I think there are basic things that courts can understand by themselves. I mean, I have not studied climate science, but I've been working in the field for 15 years, and I think like some of the things I understand. But I think it's a good idea if courts use the resources that they have and work with the tools they have, because as I write in my study, most of the courts, they already have them, and it's just they don't use them, and I don't know why. And I think this is something, as you asked for it, I don't think it needs more regulation, but it needs a better, in German you would say Fingerspitzengefühl, of the courts, so that they are able to feel whether they need it and whether their judgment is in the end supported by having one more additional round of hearings, one more additional round of experts, because in the end it contributes to the quality of the judgment. Like, yeah, if that answers the question.
Thank you. The opposition will be continued by Professor de Jong. Professor de Jong is a professor of private law at the Faculty of Law of Utrecht University and a member of the assessment committee. And I want to welcome him here at Maastricht University.
Thank you. Dear candidate, I would also like to congratulate you with a great achievement. You've managed to write a thorough dissertation on a challenging and timely topic, which is also a moving target. So almost on a monthly basis, new case law and legislation becomes available. And I can imagine it's quite hard to keep up with the pace, particularly also because you addressed many relevant legal frameworks. But of course, I'm not only here to praise you. I was immediately triggered by the title of your dissertation and the implications of it. Can you sue away climate change? And this says a lot about the starting point of the study. What role can litigation really play in preventing dangerous climate change? It does, somewhat oversimplified, deals with the effects of litigation on the real world. And one of your conclusions is also telling for the focus of your PhD. A lack of effectiveness in addressing climate change also undermines the gap-filling role of climate change litigation. Personally, I'm not so sure yet if, and if so how, effectiveness of climate change litigation matters. And I hope you can help me in that respect. That corporations and state have legally enforceable obligations to prevent climate change is beyond question. But what then is the significance of a lack of effectiveness of climate change litigation in preventing climate change? Does it mean that those mitigation obligations can ultimately not be enforced because they are not effective in preventing climate change? So I want to invite you to take position on the issue and thus to reveal your agenda in this matter. And I think there are two perspectives from which you can address the issue. The perspective of the realist and the perspective of the idealist. In the recent Shell climate case ruling, the Court of Appeal reasoned that effectiveness matters, in the sense that a lack of an effective contribution of litigation to greenhouse gas emission reductions may mean that the claimant has no interest in bringing the claim, which ultimately leads to the outcome that a reduction claim on this ground already fails. So the possibility that other actors would or could jump into the gap and thereby undo the emission reductions achieved by, for instance, Shell, would block the granting of a reduction order. The realist would see the court's line of reasoning as sensible. One does not gain anything from such a ruling because it does not lead to the reduction needed. Sue away climate change, at least not through this way. There's no justification, would the realist say, for settling a single company with the mitigation burden, while in the end no one would benefit from it. The only result is legal inequality and uncertainty. Then the idealist, who would stress that the view of the realist is rather cynical. What has happened to the idea that corporations have their own autonomous responsibility to do their part? And by still attaching value to an alleged lack of effectiveness, the court takes as a starting point that other actors would also fail to meet their obligations, even though it had already accepted that such obligations exist. After all, the lack of effectiveness is largely due to the fact that not everyone is fulfilling his or her reduction obligation. Thus, the court seems to assume non-norm compliant behavior by other actors. While that may be the reality, shouldn't express the law the opposite. So, my question is, Mrs. Nysten, are you a realist or are you an idealist?
That is a very good question indeed, and I thank you for that. Actually, I wasn't sure where you were going with this question until you mentioned Shell. Now it's clear. I think okay, how do I put this? I want to be an idealist, but I'm more of a realist. I think the court is, of course, kind of right in saying if Shell reduce, well, it was less about, if I understand them correctly, was less about just reducing their greenhouse gas emissions, but they argued like, if we stop selling oil, someone else will. And I think Shell is probably right with that. So what surprised me, however, was that this view of the court departed from the view of the Hoge Raad, who had, I think, in Orenda kind of rejected that argument when the Netherlands were arguing, yeah, but we are the Netherlands and we're so very small, and if we reduce greenhouse gas emissions, it doesn't matter. So in that case, they said, no, I'm sorry, everybody has to do their part. And so I think where I lie is somewhere in the middle. I like the Gerechtshof in the Shell judgment because I think the 45%, now we're arguing percentages again, but you asked for it, I think that was kind of a far stretch because I think it's a question of science, and from my understanding of the science, it's difficult to break down carbon budgets to a company. So I thought this was a little bit of a weird way. But what I didn't like was this idea that you call effectiveness, that Shell gets off the hook because Milieu Defensie wouldn't have anything from Shell reducing their coal, their oil production, their oil sales, and their greenhouse gas emission reductions. That's kind of like the middle way, I would say. I also, as you have read my book, so you know that I'm a bit hesitant about suing corporations in general, because I think it depends very much on the national law, and what I find problematic in a way, I'm not a law and economist person, but I can imagine that if every company in the world, and in fact I talked 4 weeks ago to a lawyer from RWE, about the Luia case. And if every company has to bear the risk of climate change litigation now, and possibly outrageous sums coming up, I mean, Mr. Luia was very, I would say, humble in what he asks for, but there could be sums. I wonder when and to what point that may, shift the balance that we have in on the one hand, we want to reduce greenhouse gas emissions. On the other hand, for the time being, we probably need the energy. So that's why I'm not super excited about tort law actions against companies, because I think there is a reason why we have left it to regulation, or why we should leave it to some extent to regulation, because that gives the certainty and the environment for the economy, for the corporations, which is difficult in litigation in general because of the insecurities that come with it. And I'd rather have it to be aligned, if that makes sense. So this is a very realist approach, I think. So make the courts talk to the legislator and the legislator to the courts, and let them find a way where we find the perfect balance in which climate change litigation and regulation work together to reduce greenhouse gas emissions. But that's what I was trying to say about the multilateral dialogue thing. I think they have to interact. I think the instruments both have to go together to make it work, because I'm with you. I think you cannot sue it away. I think that doesn't work. I hope this answers it.
Thank you. The opposition will now be continued by Professor Peters. Professor Peters is a professor of environmental policy and law at Maastricht University and a member of the assessment committee.
Thank you for that. Dear candidates, I have to put on this. Dear candidates, I would like to congratulate you with your work, and it has a very original approach. I have enjoyed reading it. I have read about the important core topics with regard to the success or the limits to successful climate litigation. And indeed, I also have prepared a question on the role of climate science in the courts, but you already investigated about that. I will address my question to EU climate law. But first, on climate science, in your presentation, you referred to the slow progress of this global governance, this cooperation. And as we know, the climate scientists, and particularly some of them, really ring the alarm bells about the situation of the Earth system. So that leads to the question of emergency actions. And particularly when we take the climate science on the tipping points, so when the North Atlantic Gulf Stream would break down, we get a major and irreparable change of the Earth system. But there are different views on the possibility of tipping points for the Earth system. So my question I have also for my research and also for you is how to deal with these emergency measures that probably have to be taken, and what role climate scientists can play. And then there should be more than one climate scientist in the courtroom because we have different views on the tipping points. But if they would happen, that would be dramatic for people. But yeah, so that was then on climate science emergency. On EU climate law. You have identified whether there are gaps in the EU climate legislation. And you have identified gaps and uncertainties. That's what you say. And I wonder, on the one hand, whether you are comprehensive enough in your analysis. And on the other hand, I think, shouldn't you be more positive on what the EU has adopted on the climate legislation? Isn't it a comprehensive framework, and what gap does actually then exist? Well, I was thinking myself about a gap, and I wondered to what extent you have thought about the aviation emissions in the sense of water vapor. So it has been discussed also by the European Environmental Agency that water vapor caused by aviation, by flights, heavily contributes to climate change, but it is not regulated yet in EU law. So I thought if you talk about a gap, in order to see whether climate litigation can be targeted to a specific activity that contributes to climate change, why didn't you discuss such a specific issue that is not comprehensively regulated and is not covered by the climate goals as codified in the European climate law that you have discussed? But on the positive side, under the Green Deal, the climate legislation has been strengthened. And I believe it's on page 101, but you state that, the EU legislator has adopted a lot. You refer to the effort sharing regulation, to the EU ETS. But then you say, the EU can only regulate on the territory of the EU, the territory of the member states. But the EU is trying to take a lead also with the carbon border adjustment mechanism, and has extraterritorial reach and the deforestation regulation. So the EU really tries now to have extraterritorial effect in its regulations. So isn't the EU trying to fill the gaps in other jurisdictions then with that legislation? And shouldn't that be highlighted then in an analysis on the legal gaps? And then finally, very briefly, one gap that you identify is that it could be a question whether the EU climate legislation just discussed adheres to the highest possible ambition, which is an obligation from the Paris Agreement. So do you mean that's a gap? But is then the answer that that cannot be solved by litigation? Because can courts really identify what the highest possible ambition should be for the European Union or for an individual member state? Yep. Look forward to your observations. Thank you.
I thank you, my highly learned opponent, for that. Those were a lot of questions, and I start with the last one, if that's okay, and then we reconstruct back. So the question of the ambitions. I identify in my work the problem of the vague formulation in the Paris Agreement regarding the ambition level. And I think this gap actually, I think this cannot really be fixed by climate change litigation, because as we discussed about Shell and more in general, also like on the Klimaatzaak thing, I think courts will always necessarily struggle with fixing a percentage. We have seen in the cases where they have done it, they have in both cases, or in Klimaatsak and in Agenda, they have fallen back to something that the government had used at some point and then done it the other way around. So they shifted the burden and said like, okay, if you want to depart from what you originally said, then tell me why you can. So I think litigation is not really the way to fill it. What I find interesting with the EU climate law in this perspective, or the discussions about greenhouse gas emission reductions targets in the EU, which is like now under fire because we're discussing the 2040 target. And there have been proposals, and the Commission is running all kinds of studies and doing things on that. And this also relates to the questions you mentioned before, the concerns you mentioned before, like the question of science. To my understanding, and I'm not a scientist, there's always some uncertainty in those numbers. And I am not sure that courts should or could or should fill that uncertainty. Of course, you might I think, as I said before, I think we should leave that to the experts, and the courts can check whether this is a reasonable, in some way, reasonable way of arguing. And I would assume that they are able to do that. But dealing with scientific uncertainty and setting greenhouse gas emission reduction targets, personally, I would be reluctant to say this is something for the courts. Unless you really have a case where there was a target and then rejected it and then explain to me this back and forth. Or where I have something where I can say, everyone agrees, because you had that kind of with the IPCC report until 2020. They said like 25 to 40% is the minimum for everyone. So then, okay, as a court, I mean, if I accept what the IPCC says as a fact, then assuming that, I could kind of do it. But we will hardly have that. And so I think the target thing, I honestly expect there won't be a lot of cases in which courts set targets. On why I'm not dealing with the aviation, I purposely focus my work on two kinds of gaps, or two kinds of rules, and then the gaps that are in those rules. Because I think otherwise this would be a book, like it would be a lot of books rather. And I think I use those as examples, and I say, okay, we look at those two kinds of rules. There's like greenhouse gas emission reduction targets for states and instruments to implement them. There's also like I have some reports that say this is the best.
But if I may intervene, if you discuss the greenhouse gas emission reduction target, if that target is not comprehensive, shouldn't you critically discuss it?
That is indeed, that is the other part of it. It's like the target itself, what do we include in the target? I think that's a whole other discussion, and I don't have it in my study, as it is, I think, not studied a lot. And I'm not, honestly, one could ask, what does the Paris Agreement say on that? What does the 1.5, what does the 2% mean? What does it stand for? Does it include everything? One should assume it does, but I'm not sure when they wrote it, did they know about the emissions from other things? So I think it's a very moving thing, and I focus on those two examples, and indeed, it's not in there. And another thing that I was like, being totally honest, when I was rereading my book, I was like, I should have done more with agriculture, because I have two sentences on the LULUCF thing, and I was like, but it's so interesting. Maybe for another book. Maybe I finish. I continue with that.
Thank you. The opposition will now be continued by Professor van Kalster. Professor van Kalster is a professor of private international law at the Faculty of Law of the Catholic University in Leuven. And he's also a member of the assessment committee, and he is present online. Professor van Kalster, you have the floor.
Thank you very much, Chair, and thank you very much, Promovenda, for your excellent piece of work. You have written a tour de force, I think. The approach you took really has implied that you had to look at a ginormous amount of cases. If you look at the Seven Center database on environmental litigation, or rather on climate change litigation, there are literally thousands in there, spread over various jurisdictions. And I found your work very attractive in that it gives a very accessible tour d'horizon of many of those cases and the general strands of direction which they take. And I want to congratulate you on that, because that really is not straightforward. Inevitably, of course, because you took such an overall kind of large approach, I think it does mean that some of the aspects that you touch upon undoubtedly could deserve more attention, as you just mentioned as well, for instance, on agriculture. And there's many other bits and pieces where you sort of tantalizingly suggest to the reader more could be said, but I don't have the space or indeed the methodology to do so. And I think that was a justifiable approach, because as you suggested in your presentation earlier as well, you took a different approach to trying to address the issues here. So very good work. I very much enjoyed reading it. I think I'm slightly more optimistic on the impact which climate litigation can have. I realize that not every case will move goalposts, but quite a lot of them do. And particularly in jurisdictions like, say, Australia, where statutory action on climate change is almost absent, these kinds of cases, I think, are really crucial to further the debate. And in turn, they inform and inspire cases in other jurisdictions as well. Now, I come to my question, which is more linked to some of your private or public international law elements, particularly on the issue of executorial jurisdiction, which Professor Peters also just touched upon, and to some degree, perhaps the effects doctrine. You conclude in that section, amongst others, on the question whether national courts may be asked to discipline corporations for global greenhouse gas emissions caused outside the national territory. And you write, and I quote, "Those developments are very interesting, as they suggest the evolution of international or at least cross-border rules for private entities when it comes to GHG emissions. However, any speculations on whether, and if so, when and how those rules will actually emerge, at least at the time of writing, seem premature." End of quote. Now, what I would like you to do for the sake of the Viva is to assume that we do need those rules and that they are emerging and that you are asked to write them. What would your matrix be for such rules? What would be the points of tension, if you like, that you would be paying attention to in describing these kinds of rules or proscribing these kinds of rules, which would determine jurisdiction for global GHG emissions caused outside the territory of the court seized? Thank you.
Well, I thank you. That's another thought piece. What would I like the rules to look like? I have a very brief section in the book on universal jurisdiction, and I've been thinking about this I like a lot, because if you say that climate change is a global problem, then shouldn't we treat it like a global problem and have rules similar to piracy? Like wherever you find the guys, like prosecute. But I mean, that is on the other hand, like difficult, I would say, not only difficult to agree on, but also difficult to execute. I am not entirely sure whether we need new rules here, because from my understanding, there's a lot of agreement in private international law and that Like when it comes to environmental damage, that you can sue in the place where the damage occurred. I think that's not a bad rule. On the other hand, again, climate change, the damage occurs everywhere. And I think it's coming back to the effectiveness question, maybe not the most effective approach. Right now, I don't really have an answer, and I have to admit that I never really thought about what would be my ideal rules for private international law on climate change, like where and under which law. My favorite approach would probably be have universal rules and universal jurisdiction, but I don't think that's feasible. So the second favorite option would be have more aligned or at least equal rules with on the substantive matter, so on the obligations of companies, so that it doesn't matter that much where you bring the action. But I can see how this is not a satisfying answer to your question myself. So I would probably have to say that it is really interesting and I need to think about it more. It's something I really didn't.
So you mentioned, Ms. Nysten, you mentioned in your manuscript, you mentioned the effects theory. And there is a suggestion that seeing as GHG emissions globally impact, that the disciplining of corporations in their place of domicile, for instance, or in the place of damage for global GHG emissions is not problematic at all, because after all, whatever they do and wherever they do it is going to impact the global atmosphere, including the atmosphere of the court that's being seized. So is this an issue where you would suggest that we are making an elephant out of a mouse, so to speak, so that we are exaggerating a problem that doesn't really exist? Or should we, like, for instance, Shell did in first instance in the Milieudefensie case, should we make a big spiel about the court being able to discipline these kinds of emissions at all?
Well, yeah, again, I mean, I think it's important. I think you should be able to bring the action where you feel the effects. The problem is that you feel the effects everywhere. As I said before, I don't really like the idea that Shell gets around the litigation by arguing that if they don't reduce it, someone else will do it. I also don't really like the factor of Shell moving their headquarters to a different state because they're facing litigation in the Netherlands. But I think this is a reality that we cannot negate it. We have to deal with it. So, yeah, I would say it's, I don't personally love that this is happening, and I think states will see that, and I expect them to react to it in a way, and I feel it needs a coordinated approach. Professor Peters mentioned the CBAM and the EU. I think it's a smart way to try to level the playing field globally so that we have similar rules and you cannot really escape them that much anymore. And I think that probably may solve questions, but as I said, like I don't have a really good answer for that right now.
If I have another half a minute, Chair, I'm sure the Chair will interrupt me if I'm
Half a minute, okay.
Half a minute. Just quickly, as you mentioned the drug dealer defense, is it correct to say that in appeal, the court, as you mentioned, unlike the Hoge Raad in the Uganda case, accepts the drug dealer defense for the stuff that Shell have already dug up or what they may have been permitted for, but suggests that it would not be an acceptable argument for new exploration of oil by Shell or others?
Brief answer.
I hope so. From my understanding, the court said that they, that they accept that they accept the argument for like new oil, that they say like if Shell's not gonna do it, then someone else might do it. Yeah, that was my understanding.
Thank you.
Thank you.
The opposition will be continued by Professor Beckers. Professor Beckers is a professor of private law and social theory at Maastricht University and a member of the assessment committee.
Thank you very much. Dear candidate, also from my side, congratulations on the book. I now leave it to second the praise that my colleagues have already made in order to allow us for some discussion still of some of the aspects of your work. I think you wrote a very comprehensive book on the different litigation, and I was quite impressed on how big your analysis is in terms of the cases you cover. But of course, you also have certain limitations if you target that comprehensively, the litigation. And one of the aspects that I found interesting, but also wondering whether it might be then too limiting in your results, is that you take a very doctrinal descriptive approach to analyzing the case law. In terms of arguing. Yeah. So it shows in your findings that you see as one of the limiting factors separation of powers and some doctrinal constructions. And I'm wondering whether there's not a limitation that you don't go deeper into the cases as what is behind those cases, because these are not simply cases or that are litigation that is brought to the courts openly to solve a conflict between the parties. It is strategic litigation. And strategic litigation builds on certain objectives, on certain resources, and certain interests. And hence, I'm wondering, if I put it provocatively, on whether there's a bit of a tautological element in your thesis by saying you analyze litigation that has inherently also a strategy of filling gaps with the plaintiffs. You mention it in your propositions, where you say a result is a lot depends on the gap that plaintiffs are targeting with their action, how they approach that gap, and the role of the courts in the respective jurisdiction. Now, in terms of analyze finding in the end how they fulfill that gap-filling objective, or more openly, maybe how your findings on the limitations would maybe differ slightly, or would you approach them differently if you consider more broadly that there are certain specific backgrounds behind the litigation that influence what gap they're targeting and what resources, for instance, interest groups have and how they're curating, let's say, the claims in relation to having a successful claim in court. I look forward to your answer.
Well, yeah, thank you for that. It's I would like to say that my approach, like looking at limitations, avoids the question of the potentials a bit. And I might have ended up doing it that way on purpose, because I think one of the, or not on purpose necessarily, but I stay with that approach because I think one of the biggest objectives of many climate change litigations is publicity. And they don't really care whether they win or not, because for them everything is a win. And I'm not saying that this is something negative. I actually feel like we have over the last, let's say Agenda Hoogeraad 2019, in the last 4 years, the public has been confronted with so many cases, and they have seen climate change is real. I especially like from the reporting in the courts, and especially those human rights-based claims and something, they have a really, like they have their own dynamic. In Germany, for example, there was a huge discussion about the Neubauer judgment, and this, oh my God, our children are affected. Like they will live in an unlivable future, and we put a lot of burden on them. And suddenly, like the public was talking about those things. And I think this is a very important element to climate change litigation that I, as a lawyer, cannot really assess. So I think it's there is work being done on the societal aspects of that, and I think they're big, and there are lots of NGOs who are building on that, and it is their strategy, as you say. It's like, this is strategic litigation. They go to court, and actually the court proceeding is the least interesting part of what they do. So it's like this whole concept, and they do it all together. And I just, this to me seems more of a social science thing than legal science, and I feel not entirely comfortable with assessing it because I don't have the tools for it. But I see the point, yeah.
But if I may quickly follow up, it impacts on the legal rules, no? So it's not only the publicity, it's the way the legal arguments are created and the way they're brought to courts. So why should this not be, my follow-up question would be, why should this not interest us lawyers? Or why can we not say anything on that when it concerns at the core also the way legal arguments are constructed?
I think it comes back, if I may, to a very interesting point. Let's discuss standing. Like, do we allow them all to go to court? Do we allow standing for NGOs? Like, not all jurisdictions are very similar, and while the Aarhus Convention says something on it, I mostly blended this out from my work. I'm not going into standing because I found that the national rules are very different. And I come from a country, like in Germany, where we don't necessarily want NGOs to go to court. And we have other tools, though. So that's why I blended this out. And from the very beginning, I was clear, like, I just say those rules are there, but I'm not going into detail because that would be another 3 books. But I think in this regard, it is important because, as you say, if we use strategic litigation, then do we allow that, and to what extent do we allow that, and how do we have to change our legal system in a way to accommodate those claims? I think, yeah.
Thank you. The opposition will be continued by Dr. On. Dr. On is an assistant professor of private law at the Faculty of Law of Maastricht University.
Thank you. Dear candidate, I have also prepared a very long speech about how much I enjoyed your PhD, but I'll just say, in the interest of time, that I think you have written a carefully researched and well-written thesis, which I've read with much enjoyment. Nevertheless, while I have found myself nodding along, reading most of the points of detail in your thesis, as I have completed reading your book, I realized that through your commitment to description and avoidance of normativity, the overall picture you painted misses perhaps the most important and significant gap in this space, which is the translation of greenhouse gas emission targets for states into specific obligations or greenhouse gas emission reduction targets for corporations, especially multinational corporations. Milieu Defensive versus Shell, a case that some of my esteemed colleagues have already mentioned, shows this very crucially, and it's also the point that was taken on as the main argument in the Court of Appeal judgment, which is, how do you translate a general duty of care into specific targets? Well, the problem is, is this indeed a gap in the global framework? I would argue yes, because companies like Shell, but also ING, BNP Paribas are also in litigation now and are making this argument that, well, they're respecting the national targets, but their emissions are global. And their argument is, well, it's not the business of Dutch law or French law to regulate our global emissions. And it's definitely not part of our duty of care. So my question to you then is, have you excluded this from your description of the existing gaps because you do not believe it is a gap? Or is this an exclusion that comes from a methodological choice that does not permit you to identify the gap, because to say whether it's a gap or not is a normative question? Thank you.
I think I have this in a footnote. Because I, in a very early draft, had the ambitious idea to look at the gaps in greenhouse gas emission reduction targets for companies, like whether there are rules on that. And then I decided to take it out because the international level doesn't have those rules. As you're right, I mean, I have this chapter you might remember on OECD and stuff, so it's somewhere in there, but it was much, much longer. I have 100 pages on that. And I decided not to do it, also because I was thinking, like, a greenhouse gas emission reduction target for a company. As the law stands right now, this would be through national translation. As I said before, we don't have a universal thing on it. We don't have harmonized rules. I don't see them emerging tomorrow. So right now, it would be a national rule for the company. And then the question is whether that's an instrument that could be imposed by the international level. I think I have to stop.
You may briefly finish your answer.
Okay, thank you. Whether that would be an instrument, like something where the international rule would say to the states, like, please adopt instruments like the EU ETS or something to regulate the greenhouse gas emission of companies. And so I was actually thinking about the EU ETS as such a system, but I was thinking it more of like as an instrument. So the gap that you're saying is I put that under instruments.
Thank you.
Thank you.
Jana Nysten, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and your defense. I request that you and your company await the results of our deliberations and our return in this room.
Please all rise.
The PhD defense has now ended. The degree committee will debate the candidate's performance behind closed doors. This process usually takes about 10 minutes.
Long road to the south side. 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. The line, I know you know that I can't read your mind. Years can't fly by now, don't waste all your time. Cause I'll go the extra mile. Long road to the south side, 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. On the dash, got my laces tied. Long road, I don't waste no time. Break rules because fate decides. With the team and we chase the light. I make a move, fall down, shake it off. I hate to lose, bad branch, break it off. No room for negativity, praise and love. Prepare for deep part cause we're taking off. Take the mileage, traveling so far from home. Gathering knowledge, other connections. I put the time in to get everything I ever hoped for. It's a challenge and we all in. Better future that we go for. And even though these nights seem long, I know that I am never on my own. Know you won the battle once you've grown. South side, 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. Long road to the south side, 10 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. can't fly by now, don't waste all your time. Cause I'll go the extra mile.
gesagt, Erik, jetzt kommt dein großer Auftritt.
Ja, was soll ich denn?
Das legst du hin. Ich glaube, erstes musst du dich festhalten. Mach halt irgendwie.
Jana Nysten, the degree committee here present has assessed the quality of your thesis and your defense. In view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Farroy is authorized to confer upon you this academic distinction in accordance with Dutch university custom. I invite your supervisor to now take the floor.
Please all rise.
Do you promise to work in accordance with the principles of scientific integrity at all times, to be careful and honest, transparent, independent and responsible?
Yes, I promise.
By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Jana Viktoria Nysten, the degree of doctor and grant you all rights attached by custom and law. As evidence of this, I now present you with the degree certificate signed by the rector, the secretary, and the other members of the committee, and affixed with the official seal of the university.
Okay. Dear Dr. Nysten, young Dr. Nysten, dear Jana, it's a great pleasure that I can congratulate you together with the other supervisors for this great achievement. During the past years, you have written an excellent and very informative book on climate change litigation and defended your research and findings here today in a very, as some people said, refreshing and special and excellent manner. Our acquaintance goes back already to a period even before you started your studies here in Maastricht. And in light of this early meeting and the circumstances of this meeting, I would like to address you now first and your family in German. Jana, das erste Mal, dass wir uns getroffen haben, war im Haut-Gouvernement im Raum 1019, dem sogenannten Chambre des Députés, während eines Tags der offenen Tür. Gerade in diesem Jahr hatten wir uns als Fakultät dafür entschieden, um auch, wie bereits die Fakultäten SBE, Volks- und Betriebswirtschaft, und FASOS, Kultur- und Sozialwissenschaften, Studenten aus Deutschland für das rechtswissenschaftliche Studium in Maastricht zu werben. In Deutschland bestand schon geraume Zeit Kritik an der traditionellen deutschen Juristenausbildung mit dem Staatsexamen, und wir hofften, mit der European Law School einige deutsche Schüler von unserer international orientierten Juristenausbildung überzeugen zu können. Zusammen mit deiner Mutter warst du aus Aachen nach Maastricht gekommen, um dir die Universität und auch die juristische Fakultät anzuschauen. Zusammen mit einigen ebenfalls deutschsprachigen Kollegen erwarteten wir mit viel Interesse, ob wir tatsächlich deutsche Schüler von unserem Unterrichtsangebot, von den kleinen Gruppen mit problemorientierten Unterricht überzeugen können. Deine Mutter schien direkt begeistert und überzeugt zu sein. Wir hatten keinen Zweifel, sie würde sofort bei uns ein Studium beginnen, falls es um ihre Studienwahl ging. Bei der Tochter waren wir nicht so sicher. Du schaust uns mit diesem etwas skeptischen, fragenden Blick an, den du hast, wenn du noch nicht ganz von den Argumenten deines Gegenübers überzeugt bist. Diesen Blick sah ich während unseres Supervisory-Trajekts auch ab und zu wieder. Meint ihr wirklich, was ihr mir jetzt erzählt? Oder sollen wir erst noch mal seriös darüber diskutieren? Ihr, die PhD-Supervisors, müsst mich wohl erst einmal konkret überzeugen. Mit diesem skeptischen Blick schautest du uns ab und zu an während unserer Zoom-Sitzungen. Wenn wir dich aber überzeugt haben, gingst du auch sofort mit vollem Schwung an die Arbeit. Genauso war es bei unserem ersten Treffen am Tag der offenen Tür. Du stelltest kritische Fragen und wolltest überzeugt werden. Anscheinend konnten wir deine Zweifel entkräftigen, denn letztlich hast du dich ja für ein Studium an der European Law School entschieden. Und ich glaube, du hast es auch nicht bereut. Now I will change back to English. After having finished your trajectory in Maastricht, you studied in the US, acquired the New York bar qualification, worked as a practicing lawyer in Brussels and in Berlin, in Germany, and finally now as a senior researcher at the Stiftung Umwelt-Energierecht. After you had finished your studies in Maastricht, we stayed, and I would call it, in a light contact. You sometimes informed me about your international professional endeavors, which seemed to be very interesting and exciting. A clear and very possible example of an alumna of the European Law School. Suddenly, however, I received, if I remember correctly, June 2021, an email from you about the vague idea of a possible external PhD project, which you considered in light of the increasing number of climate change-related litigation. You thought that this could be a topic you could get excited about during a PhD trajectory. We started a first discussion on the issue by phone. I told you directly that even if I had followed, especially the Dutch and German cases, as well as the international litigation rather closely, that I would be very much like to ask Michael Faure to join the supervisory team as expert in the field, and also later to ask Pauline Melin, who also agreed to do this. So we started together our mainly online meeting discussion of the research project in more detail in October 2021. You started with an enormous energy, producing large parts of the manuscript. Already in December 2021, I found in my files, we received a first, if I'm not mistaken, second draft of part 1. And as you have told us already, you have 100 pages over for private litigation issues. Yeah? So the next book might come. Sometimes you surprised us with a new and updated version while we were still in the reading process of an older version. Sometimes we had to bring you back to classical academic style of writing and argumentation, but you are a very fast learner. Very soon we realized that this external PhD project will be finalized faster than many classical PhD trajectories. We guessed that you have found a new hobby, writing chapters in the weekend with an enormous speed. We were very impressed by your enormous workforce and energy, your ability to formulate fast and precise, and your knowledge of the increasing body of climate change litigation cases all over the globe. This knowledge and insights you have brought now all together in this book. You developed an own categorization which might be helpful to predict successes and failures for future litigation, but you are not naive. One cannot litigate climate change away, but with all the climate change litigation around the globe, the awareness concerning the most pressing issues have increased enormously. So it might not lead directly to changes, but the awareness has changed. You can be very proud that you, with your research, has contributed to this further awareness, but also to the systematically researched knowledge in this important field of law. We as supervisors enjoyed very much to be directly involved in this project. We sincerely hope that you will continue with your academic work next to your professional work. We are sure that you will follow the new cases and judgments closely. There are enough which ask directly your attention and the formulation of comments, as we discussed the Shell case. And next week, the International Court of Justice is coming, so we have enough work to do.
Good.
At this very moment, one cannot open a newspaper without reading about a new judgment or unexpected litigation. We hope that we will read regularly your comments and articles. Furthermore, we hope to see you during conferences and workshops, but also during a lecture which you might be willing to give for the future generation of European law school students. You can be assured that your contribution will sincerely be appreciated. As the book is now finished and defended, you might have to find a new hobby for spending the weekend. Staying engaged with the academic community might be one, next to walking the dog. In any case, dear Dr. Nysten, dear Jana, all the best for the future. We, as your supervisors, as your Dr. Eltern, and you are quite modern, 2 mothers and 1 father, are enormously proud for your achievement. Wir wünschen dir und deiner Familie, aber auch deinen Kollegen von der Stiftung Umwelt-Energierecht alles Gute, genießt den Erfolg und hoffentlich auf weitere gute Zusammenarbeit in der Zukunft. Die Erde und ihr Klima hat Forscher wie euch nötig.
Dankeschön.
Dear Dr. Nysten, also on behalf of Maastricht University, I congratulate you with the degree you have just acquired. And hereby I close this academic ceremony, and I would like to ask the young doctor and the members of the degree committee to remain in this hall to take a picture together with the Professor van Kalster, who is online, and then afterwards go to the central hall for another picture on the stairs. And in the meantime, I would like to ask your company, your family and friends to go to the reception room, which is in another part of this building. Thank you.
Wir machen ein Bild.